Hey, it's your old buddy Brian Parker coming at you with a good one. We're going to bring out the word linchpin today. As you know, when we analyze a collection lawsuit, you look for the linchpin. What's the linchpin? That's the part of the lawsuit that if you take that away, the whole thing collapses. So I've got a number of videos on linchpin litigation. Those are a couple there. This is actually, this is a lawsuit that a member of KillDebt.com faced or is facing, and she's done her own answer. She's come to me after she did her own answer, which is a pretty good answer on her own, but she can tell she needs to beef it up, and we had a discussion about amendments. But this is based upon a Federal Trade Commission lawsuit against this company called, this is new to me, so I'm going to try to educate you without boring you, called Growth Cave. It's a credit repair and wide-ranging business opportunity scam that's been operating since 2020. The FTC's complaint, and I'll put a link below, states essentially that the operation owners Lucas Lee Tyson, Osmani Batty, also known as Ozzy Blessed, and Jordan Marksberry ran the Growth Cave operation, taking $50 million from consumers using false promises of huge income and online marketing scams. So the FTC alleges its primary scheme is called Knowledge Business Accelerator, KBA. With the KBA scheme's central pitch to consumers is that by developing and marketing a so-called digital education program, consumers can generate $20,000 to $50,000 in passive income. In videos cited in the complaint, Lee Tyson guarantees it's literally impossible to fail. Wow. According to the FDCPA complaint, consumers who reach out learn about the KBA program, and upon contacting them, it's like a virus, they get hit with constant email marketing, videos, deceptive messages, and are pushed to watch more videos and schedule a strategy call with the Growth Cave employee that eventually, just coerce them into a promise of a $10,000 a month guarantee. And then they're told they can recoup the money they spend with Growth Cave when you buy the KBA business opportunity. Because again, the guy said it's impossible to fail. So here, the member was coerced into signing up for a $10,000 membership, which they happily financed for her with a Fintech loan. You've heard me talk about the Fintech loan explosion from a company called First Electronic Bank. Thereafter, tried to cancel immediately. But in the loan agreement, First Electronic Bank sneaks in, well, it's in there. It says this loan is between the lender, which is First Electronic Bank, and the seller, which is United National Credit. She has no idea who that is and what is being sold. Actually, in the agreement, let me put the thing up there for you so you can take a look. This is the promissory note and disclosure form, Shazamsky, and that says the seller is United National Credit. She's not, so you can look, it says the goods or service being purchased, they write goods or service being purchased. So it's kind of weird. But the lender is the original creditor. There is no reason to have a seller involved in this. But if they're selling something, they obviously must have a title to something, which that never comes out to be as true. So this is the beginning and background of a lawsuit that the member is facing. I just want to tell you who United Credit is. They're a fintech loan company, and how most fintech loans, you'll see them in Cross River Bank, Upstart, FinWise Bank, Blue Ridge Bank. What they do is they partner with real banks. United Credit is not a bank. It is a platform that helps consumers with varying credit scores. First Electronic Bank issues the credit. It's a Utah chartered industrial bank. It acts as a partner bank that issues the various types of credit, and in collaboration with the fintechs, another company. The arrangement is sometimes referred to as rent-a-bank. That right there. Anyway, consumer receives credit from the bank. When a consumer gets approved for the financing through United Credit's platform, I've been seeing these words AI platform for about 2 years now to explain why there's no proof when I'm suing Velocity or Crown Asset, why there's no proof showing the original creditor send it somewhere, to send it to a trust, to eventually get it to the people suing my client. And to every attorney, to a man and woman, I hear, well, Your Honor, it's an AI platform. What does that mean? It needs further explanation. So the member tried repeatedly to cancel through letters, emails, and calls, but they just put up a big brick wall once she signed on the line that is dotted. When she refused to pay, because she believed she canceled, she started getting letters from your old friends, Mandarage Law Group. I have them in my crosshairs, if that's the way to put it, not nicely, kindly, a lot. And they're fun because they appear to be overworked and their attorneys never get back to you. So I use that against them. Well, that's another video. So the member sent a validation letter saying, who are you representing? Why are you trying to collect this debt from me? And she found out that a company called Independence Capital Recovery LLC is the sole owner of the debt at issue. Independence Capital Recovery's LLC account number is blah, blah, blah. And they give the address and they say Mandarage is collecting on a debt, which is all it does. It doesn't do anything else but collect on a debt. So she wrote a letter to the California regulatory agency responsible for governing these type of situations under collections, and they responded to state of California, but she gets the copy of the letter, and this is the letter from a company called ICR showing that they own it, Shazam. And some points here, they mention Grove Cave a lot and say, please stop mentioning Grove Cave. This is about your loan with United National Credit. This is all United National Credit. Stop bothering us with this stuff. You owe us. And if you don't believe us, we've got paperwork proving it. So we're gonna look at the paperwork proving it that will directly contradict with the lawsuit against this member. So this is your basic nightmare fraud campaign that the member was unfortunately part of, that's now jettisoned into a lawsuit with new debt buyers and everything. It's just your average, fintech. In a sense, I appreciate that the law firm and the people that eventually sue the person that took the fintech loan will never have proof that they own it. But they're left to go fight it out. And because 9 out of 10, up to 9 out of 10 people don't complain, they get away with filing a lawsuit they're unjustified by. And this is your average one, and I'll show it to you today. I just want to put up a quick background. The National Consumer Law Center has specifically critiqued First Electronic Bank. That's the one that Grove Cave said was going to finance the $10,000 to them. They've looked at the kind of techniques they use. Here's a link to the National Consumer Law Center. And it's, as always is the case, this is a company that provides you with excuses in the form of paperwork, the better for us. So these, essentially what the National Consumer Law Center is saying, First Electronic Bank's involvement with fintechs is a way to offer triple-digit APR loans, and they argue that it helps those lenders evade state interest rate limits by operating under a bank charter, rent-a-bank. So they are able to charge enormous rates, I gotta choose my words here, by claiming, no, this is a bank that's doing this, not us. So in proving that ICR owns this debt, they sent that letter, and then they sent a bill of sale, and then they also sent a certificate of loan transfer, which is a very common thing in fintech collection debts. So in the above letter, I want you to key on, let's show you that letter from ICR again, Shazam. They say, as noted above, the charged off account was assigned to ICR. We include a copy of the bill of sale showing the transfer of ownership to ICR. So remember that. It also refers to Mandarage Bank as its service provider after the debt was charged off. ICR placed his account with its service provider, Mandarage Law Group, for collections. A servicer or service provider is a provider of account services for the thing that is owned by somebody, and they provide the services or the goods that the owner is providing, but they do it for the owner. So Mandarage Law Group is not a service provider servicing this debt when the debt has been charged off. Because a debt collector collects charged off debts for a third party, ICR, and provides no service of any kind for the original purchase of the goods. This debt was charged off. Mandarich collects debts. But let's look at the bill of sale and have some fun here. And this is the meat of the act where this has led to. This poor lady is subject to lawsuit. So if I'm gonna look at their paperwork and I'm gonna give you my opinion, you take it for what it's worth. I'm not giving you legal advice. But Shazam, here's the bill of sale. This is a fun one. This is why I get up in the morning. I see this in my sleep. I wake up. I love this stuff. But I also get very frustrated because I will say to a court, this. There's no way this person owns it. And then the judge sometimes will go, yeah, but she took the loan out. Like that contributes in any way, shape, or form. It doesn't to ownership. But they are saying they own it because of this bill of sale. So let's look at the bill of sale. So let's look at the problems. Well, first, this convoluted statement. It says, under the bill of sale, Lending Point acts as the administrator agent on behalf of Lending Point 2018-1 Funding Trust with respect to the accounts that LP Funding Trust owns on behalf of Coastal Community Bank with respect to the accounts that Coastal Community Bank owns and on behalf of Alternate Lending Holdings Trust 2 with respect to the accounts that Alternative Lending Trust 2 owns. I do that because it sounds like a mess. If it sounds like a mess, it's not very clear as to who owns anything. I remember a trial I did many moons ago. It was an eviction trial, and there was this awful sounding trust. I said it as many times as I can to the jury because it was so confusing and almost laughable by the 10th time I kept asking about this. It got so messy because it was messy. I wanted to process messiness, and they're doing it here. So number one, here's the problems with that bill of sale that goes into your counter affidavit. And your answer, your affirmative defenses. Lending Point 2018-1 Funding Trust and Lending Point LLC are different entities, but there's no documentation showing how the debt transfers between them. And at this point, how did Lending Point get the debt? Who gave it to them? I thought it was this First Electronic Bank or whatever it is. So number two, the bill of sale states Lending Point LLC acts as administrative agent for multiple entities. Lending Point 2018-1, Coastal Community Bank, Alternative Lending Holdings Trust. You got to use their documents in the language against them because they're using it against you. So just read it. The emperor is not wearing any clothes, Your Honor. This is DOA, dead on assignments. But it doesn't provide here the actual agency agreements or documentation proving Lending Point LLC has the authority to sell anything. Number three, the underlying account purchase agreement. That's that forward flow agreement that the bill of sale is always pursuant to. Where's that? The closing date is either August 26, 2024, but the bill of sale is dated August 29th. Remember that date, please, for this video. The complete account purchase agreement, the forward flow agreement, is not attached. Look at the signature. Go back to that bill of sale from Greg McLaughlin. Who does that guy work for to sign this? Especially in California and Michigan, you have to show you have authority to sign a document that's in writing for you to have a proper assignment. It's called the statute of frauds. Who is he signing for? It's got to be, quote, the party that is charged. It doesn't say who he is. He may well be who he thinks he is, but it doesn't say. Why? Because there's like 4 or 5 entities there that they want to claim that he signed for if it ever comes out with this convoluted mess. So, but most important, look at the couple of pages of the lawsuit I'm going to now present you. So here's the first page of the lawsuit. That's just Independence Capital Recovery. It's from Mandarich. But here's the fun stuff that you can use with your old friend Linchpin. Look at second page. And look at number 8. Plaintiff purchased the debt from First Electronic Bank on 8/29/24. Let's go side by side. The bill of sale. There is no reference from First Electronic Bank selling that to ICR. There's no reference for First Electronic Bank selling it to anybody. And why are they not saying this chain of title that ICR itself is representing happened in the bill of sale? But it gets worse. So that's your linchpin. If you can knock that out, and it's a misrepresentation. Plaintiff purchased the debt from, well, we already know that ICR is claiming they purchased it from Lending Point or Lending Point Trust 2018-1, whatever the heck that is. So that's using their own documents and complaint. That's the linchpin. You knock that out, you knock out the case. So let me just put that specifically up for you so you remember it. Shazam. Plaintiff purchased the debt from First Electronic Bank. Well, you know the bill of sale states that the Lending Point LLC sold the debt. So the complaint at paragraph 8 is false. You use their own documents against them. But it gets worse for them. August 29th supposedly is when Greg McLaughlin signed this bill of sale for somebody. I guess that's the effective date, but they attach with that a certificate of loan sale. And that's First Electronic Bank. Okay, they're gonna send it to somebody. And they send it to Lending, no it isn't. Number 3 says, we transferred or otherwise conveyed to Lending Point 2018-1 Funding Trust, each loan in Exhibit A. There is no Exhibit A, so we don't know if our member's debt is in there. That's important, obviously. So the transfer is assigning to transferee Lending Point 2018-1. That's not in the complaint. They're saying First Electronic Bank sold it to Lending Point and didn't sell it to ICR. I'm not sure if the defendant's loan was ever in here, but it gets better. The date, check the date out. September 3rd, 2024. There's 31 days in August, so that's 31, that's 5 days later. First Electronic Bank, which is the creditor who owns it and holds it until they sell it, 5 days after the bill of sale is signed as proof of ownership, First Electronic Bank is selling it for the first time. So, number 1, here's the problem. This certificate was signed on September 3rd, but the bill of sale transferring the loans from Lending Point LLC to Independence Capital Recovery was executed either August 26th or August 29th, 5 days earlier. So the question is, hi Steve, the question is, how can the Independence Capital Recovery claim ownership of loans that weren't even certified as properly transferred to Lending Point 2018-1 Funding Trust until after they supposedly already owned them? Number 2, the certificate refers to an attached Exhibit A. There is no attached Exhibit A, no loan numbers, nothing identifying this member's name, account number, or loan was transferred anywhere. So this lawsuit is DOA, dead on assignments that they supplied us. So all this should be in your counter affidavit, which is attached to your well-pled answer and your affirmative defenses, which can all be created for you with just a prompt. Go to Parker GPT, there's a prompt box, use it like a Google search, go, hey, can you give me an answer in a counter affidavit and affirmative defenses to the thing, upload their answer and their bill of sale and the certificate of transfer. I did that. And up will pop either an answer, an affirmative defense, whatever you want. And by the way, check out the rocket ship. You click on the rocket ship, it tells you the real question to ask so you can get a better response. Or you say, hey, this thing is DOA, dead on assignments. Give me a motion to dismiss based on this paperwork, and then file the motion to dismiss. Don't bother with the answer, because if you win it, you don't have to do the answer affirmative defense. You always have to do the counter affidavit. Number 1 rule, always have a counter affidavit with whatever you file with the court in response to pleadings or filing a motion. But go to killdebt.com for a complete debt lawsuit defense checklist. You know I love my checklist. I make a checklist for you. So I created a debt lawsuit defense checklist. It's a chain of title analysis I've done in the past, but this incorporates all this information, everything into a checklist. So you go, okay, okay, I'm gonna do the chronology like we just did. I'm gonna challenge the standing. It gives you great information, and it is all embedded in Parker GPT with over 1 million cases so that you can avoid the hallucinations that most AI chat boxes give you. They make it up all the time, I know. I stopped using Chat GPT because there was so many cases it made up. I was constantly checking cases and adding work to my job. So Parker GPT stays in its debt defense lane. And like I said, we have 1 million cases from state and fed at the highest level to the lowest district court. Even, I believe we have motion arguments, where you can watch motion arguments. And so that's your case searcher. So we've got it all. We've got 1,200 documents in there. Every lawsuit, every Fintech arrangement, every motion, every discovery question you have, it's in Parker GPT. I hope this video helped you become alert to this scam that's out there. Also how it fed into this poor member's lawsuit she's facing. But hopefully this provides her with some education, as it does all of you, to go get these guys, all right? So go get these guys. Bye-bye now.